हेलो नीलूफर, आतिफ, को श्रेयस। श्रेयस आज इसमें भी नहीं आए। सही है। Am I audible? Am I audible, Shreyas? Great, great. My video is not visible.
Yes, it's not your videos.
Huh?
Yes, it's not your video.
No, I think it's from here. Okay, so let me see what I can do here. Am I visible now? Or at least the class is visible now? Great, Shreyas, great. So let me know if there's any other issue. Fine. So we have discussed all this. We have discussed executive power. Any confusion here? Anyone? Dheerja? Siddharth? Impeachment is also done. Now we have to discuss powers of the president. Fine. So powers of the, where is Madhu? Where is Madhu? Okay, so powers of the president. Fine. So what we'll do, we will try to, have we started the powers or not? We haven't, right? Huh. So essentially what we have done, in order to understand powers of the president, we essentially will be looking into different powers of the president put into different brackets. Of course, executive powers, then what can be called as legislative powers. But then what we need to keep in mind is it will only be kind of quasi-legislative. Then financial powers, then quasi-judicial powers, diplomatic powers, military powers, and of course powers pertaining to emergency. Fine. So let's try to look at them one by one. So when we talk about executive powers, few of these points we have already discussed. What exactly do we know? We know that all executive actions of Government of India will be taken under the name of President of India. Fine. That is all executive decision. Any executive order passed, it will be done under the name of President of India. He can make rules specifying the manner in which orders and other instruments made and executed in his name shall be authenticated. What do we mean by this? The idea is that whenever you are essentially sending him any executive order to be signed, the idea is it is up to president to decide the manner in which it should be presented. Let's say, जैसे वो नहीं होता कि in experiments that we used to do, the fact that object of the experiment, procedures, right? The idea is that format is something that president will actually prescribe, can tell to the executive, this is the way in which it should be given to me. It can also be the fact that only on Thursdays I will sit and sign all your executive orders. It can also be the fact that I want for any executive order that you want me to sign, you need to first give it to me in 4 days advance. Why? So that I can consider it, that all the matters and everything that you want me to sign are in order. Fine. He can make rules for more convenient transaction of business of the union government and for allocation of said business among the ministers. So what exactly are we saying? So the whole idea of passing executive orders means what? That he will be getting orders, or rather executive orders from the prime minister. He will be getting executive orders from the cabinet. He can be getting it from separate ministers. Of course, with respect to separate ministers, what do we know? If president wishes, that order, that decision can be considered by whom? By the cabinet, by the council of ministers. If the president wishes, this is an order that should not be coming only from one minister. It should be coming only after scrutiny of council of ministers. He can send it back. Fine. But then what exactly are we saying? With respect to taking all these orders, all these matters, he essentially can develop those rules, make those rules by which he will process all these executive orders that are being sent to him. Anyone getting confused as to what exactly executive orders are? Right? Government of the day, on day-to-day business, every ministry will need to do what? Will need to pass executive orders. In this regard, president will need to sign it because first point, all executive actions will be taken under his name. In this regard, how exactly he wants to go about it is something president can decide. He appoints the prime ministers and other ministers. They hold office during his pleasure. Fine. The whole idea is this pleasure in itself is not absolute here. It only means as per the constitution, as per parliamentary democracy. but then appointment is done by the Prime Minister. How exactly generally it gets done? So let's say new Lok Sabha election happened. Let's take the example 2019 itself. So what exactly got done? That Prime Minister Modi ji, he got on a piece of paper signature of all those people who want him to be the Prime Minister, and he goes to the President. President then will look into the document. How many people is it satisfying the necessary criteria? If it is, Mr. Modi, you are now the Prime Minister. Then Modi sir, please present who exactly do you want to be in your Council of Ministers. Then portfolio allocation will happen, and then President will also ratify that. He appoints Attorney General of India and determines his remuneration. The Attorney General holds the office during the pleasure of the President. What exactly do we mean by it? Who is Attorney General? Attorney General is the highest law officer of the country. Attorney General is appointed by the President, and Attorney General exercises his functions, exercises duties during the pleasure of the President. What exactly do we mean by pleasure here? Again, when we study constitutional body, we study about Attorney General, but here the point to keep in mind is, with respect to Attorney General, it is absolutely up to President when to appoint him and when to dismiss him. So it can be within 15 days, it can be for 5 years, you can have the same Attorney General. Why exactly is that the case? Anyone? Because Attorney General essentially what? Is the lawyer of the government. What exactly do we mean by lawyer of the government? See, let's say there is a case that has been filed with respect to constitutionality of CAA. Right? It's a case. Who exactly is supposed to defend it? Government is supposed to defend it. Let's say there is a government order that has been passed. Again, constitutionality or legality of that order has to be defended. Let's say there is a charge against the government with respect to any action they have taken that essentially led to damages of some people. Again, government will need to defend it. Who exactly will be defending the government? It will be a lawyer. That lawyer is called Attorney General of India, right? We are keeping it simple. जब Attorney General पढ़ेंगे, we'll understand about all the other lawyers also, which Government of India has. But here the idea is the highest law officer of the country is called Attorney General of India. Now the logic is pretty simple, that I would want that lawyer to represent me on whom I have my confidence. My confidence cannot be subjected to a tenure. My confidence is till my pleasure is. In this regard, what do we see with respect to Attorney General? The Union government has the power to appoint and dismiss Attorney General as their will. In this regard, it is going to be the President who will be acting under the aid and advice of the Council of Ministers. Fine. He appoints the CAG, Comptroller, Auditor General, Chief Election Commissioner, and other election commissioner, chairman, members of Union Public Service Commission, governors of the state, chairmen and members of Finance Commission, and so on. So what do we see? Even with respect to appointment of all these important functionaries, mainly the constitutional position bodies, we see it is the President who is doing the appointment. Any doubt in this regard so far? What?
The public prosecutor.
जी वो तो गवर्नमेंट लॉयर्स हो गए. देयर इज अ डिफरेंस. फॉर एग्जांपल देखो, एक होता है who actually fights on behalf of the people. So in there they have district attorney, that is in US system, Western country. So essentially that in itself is an elected position. But India, the system that we have is, let's say you go to court, or rather there is a case that has been filed against you, or you go to court and you do not have the money to sort of fight the case. So the court, that is judiciary, will essentially appoint. That will be your prosecutor, right? In US, they have something called as district attorney. So that guy himself is actually elected by the people, and that guy will be fighting the case, right? Whenever you get confused, have you seen Batman, Dark Knight? So Harvey Dent tha. He can speak any information relating to the administration of affairs of the union and proposals of legislation from prime ministers. What exactly are we saying? What we're saying is that on matters of administration, if he wants information, he can get it from prime ministers. Let's say there is a legislation. There is the planning of introducing some bill in the legislation that government is planning. The prime minister, your president can actually ask prime minister, sir, please give me any information if you have with respect to any proposal that you are planning. Fine. He can require the prime minister to submit for consideration of the council of ministers on any matter. The decision has been taken by minister but not has been considered by the council. The same point we discussed. The idea is that it could be that president gets to know that there is an order that has been passed by one of the ministers, but he believes this is such an order, it is such a sensitive matter, and this order should be considered by Council of Ministers. So what he can do, he can ask that order to be considered by Council of Ministers, and if the Council of Ministers still believes this order should be passed, President will pass that order. Is it clear? He can be appoint a commission to investigate into conditions of SC, ST and other backward classes. So this again we will study in detail when we study about National Commission of SC, ST. This power of the president. He can appoint interstate council to promote interstate and interstate cooperation. So the whole idea is that there is something called as interstate councils that can be made by the president. That is, if there are issues, let's say water sharing, let's say with respect to resource sharing, a project that is getting built and that is going to affect both states, right? Such a project, on such matters, it could be necessary that interstate councils are formed. President has the power in order to ensure such kind of coordination to happen, to form such interstate council. Siddharth bhai, fine. He can appoint an interstate, he can directly administer union territories through administrators appointed by him. So we have already studied something about UTs. What exactly we studied? That these are those territories which are directly under the control of union. These are strategic locations where it is necessary that it is under the control of union. Now administration will need to happen. How exactly administration happens over there? By the president. Now president himself might be busy, so what he can do? He can appoint his officers. So lieutenant governors. Is it fine? Clear with everyone? Right? In this regard, he can actually administer all matters of UT. He can declare any area as scheduled area and have the power with respect to administration of scheduled area and tribal areas. One of the things that we had discussed was what? That in India, there are certain scheduled tribes. There are certain areas where essentially these tribes are living. They are living their customary way of life. They have their own culture. They have their own kind of constitution practices. The idea is that we are trying to protect that also. In this respect, what exactly will we be protecting? These areas. In this regard, what we have done, we have actually classified some area within India as scheduled areas. These areas are those areas which essentially will not be governed by the states in which they come under. For example, they can be scheduled areas in your Chhattisgarh, they can be scheduled area in Madhya Pradesh, right, in Uttar Pradesh. These areas have been identified as scheduled areas and will be administered directly by President of India, that is Union. In this respect, President can also come to know that there are more areas which can be classified as scheduled areas. So President has the power to do that. That is, if he gets to know that there are these areas which should be considered scheduled areas, he can declare them as scheduled areas and can do what? Administer them accordingly. He can declare any area scheduled area. Any confusion? Anyone? Fine. Let's look at legislative powers of the president. So one of the things that we have studied is that when we talk about parliament, what all it includes? Lok Sabha, Raj Sabha and President of India. In this respect, what exactly are we talking about? What we are talking about is President is integral part of Parliament of India, because for several important things for law making process, President is playing a very important role. In this regard, the first of course is that he can summon or prorogue Parliament and dissolve Lok Sabha. Something that we have studied, that if a new parliamentary session has to be summoned, it has to be called upon. Who has the power to do so? President of India. If the session has to be ended, who has the power to do so? President of India. Right? He can also summon a joint sitting for both houses. When exactly joint sitting can happen? When there is a deadlock. We have already studied what can be the ways in which deadlock can happen. Right? Any confusion? Fine. He can address Parliament at the commencement of the first session after each general election and first session of each year. What exactly are we saying? That President of India every year before the budget session, that is the first session, essentially comes and gives a presidential address. If there is a new Lok Sabha that gets formed, again President will be the person to come and give an address. The whole idea is that with respect to this parliamentary convention, President is the only office which plays a role. As such, again, a kind of legislative power. He can send messages to the House of Parliament, whether with respect to bill pending in the Parliament or otherwise. So the whole idea of President having the power of summoning and proroguing Parliament is about what? Is about ensuring that legislative business of the country is getting done. What exactly do we mean by legislative business? That is law making process. In this regard, law needs to be made with respect to important aspects. For those aspects, we might be having those bills. Now, if President is saying that there are these important bills which are yet to be discussed, yet to be deliberated, to be voted upon, and they seem to be get kind of stuck up because दूसरी चीजें हो रही है, लड़ाई कर रहे हैं, वगैरह वगैरह कर रहे हैं, तो then what he can do, he can actually send this message that President has sent this message to please consider these bills and please speed up the process so that we are able to get legislative business done. Are you able to understand? He can appoint any member of Lok Sabha to preside over its proceedings when the office of both Speaker and Deputy Speaker fall vacant. Similarly, he can also appoint any member of Rajya Sabha to preside over its proceedings when the office of both Chairman and Deputy Chairman fall vacant. What we are saying is, so abhi to we are studying President, then we'll study Vice President, and then we'll study Speaker, Deputy Speaker, and Deputy Chairman. Fine. What exactly are we saying? What we require for Lok Sabha to kind of work is a presiding officer. Presiding officer is Speaker. Let's say Speaker is not well, Speaker is not there, Deputy Speaker. Let's say Deputy Speaker is not there, then who exactly will preside? President can appoint the person who essentially is going to do this function, right? Who is the Speaker right now? Om Birla. Who is the Deputy Speaker? We don't have a Deputy Speaker, fine. Abhi to, for now, that is the case. He nominates 12 members of the Rajya Sabha from among the persons having special knowledge or practical experience, literature, science, art, and social service. What exactly are we saying? That President has the power with respect to nominating members to Rajya Sabha, and what we see that 12 members are getting nominated. So, do these nominated people play a part with respect to impeachment of the President? Yes or no? They play a part. They have the power to vote. Do they play a part in terms of election of the President? They don't. Fine. Something to keep in mind. Nominated members participate in impeachment of the President. Nominated members do not participate in election of the President. Clear? Fine. Please keep it in mind. Very important for prelims. Acha, he can nominate 2 members of Lok Sabha from Anglo-Indian community. This practice has been ended. Fine. This practice has been ended. 2020, this practice got ended. Fine. Now, President cannot nominate, President does not nominate Anglo-Indians into this. He decides on questions as to disqualifications of members of the Parliament in consultation with Election Commission. What exactly are we saying? The idea is that you have to be qualified as per Constitution and as per Representation of People's Act in order to fight the election. In this regard, what can happen? That you not being qualified might be discovered at a later stage. That is, when you have become an MP. This can be something new has happened, or for that matter, you had hidden something. Are you able to understand? For example, you showed wrong qualifications, or there was some criminal history that you decided to hide. What exactly is it amounting to? Disqualification. Who exactly has the power to disqualify? President of India will disqualify. Something to keep in mind is who exactly will perform the investigation and recommendation? Election Commission of India, and this advice is binding on the President. Are you able to understand? So with respect to disqualification, what do we see? That it is the Election Commission of India which deliberates matters of disqualification, and the advice given by them is binding on the President. Let's say Election Commission has given a advice that yes sir, we are giving you advice to disqualify Mr. X, and your Council of Ministers is giving this advice, sir, we do not want you to dismiss Mr. X. What exactly should President do then? Dismiss. It is constitutional requirement on the part of President to follow what Election Commission is saying on matters of disqualification. Let's say there is a case with respect to anti-defection. That's a way in which a person is getting disqualified, and let's say Election Commission is saying, sir, you should disqualify, and Council of Ministers is saying, no, you should not disqualify. Then what President should do? Both doesn't matter. It's the Speaker who decides it. We will discuss about it. It's the Speaker with respect to disqualification through anti-defection. The power lies in the hands of Speaker or Chairman. They are the people who essentially decide what, that should a person be disqualified or not, and whatever the decision is, that will be final. That has to be done by the President. It is not Council of Ministers. This is where they may confuse you. Fine. We'll discuss anti-defection also. The point is, this is where they may confuse you. That you may think that it is Council of Ministers, but that is not who will be giving this advice. It will be the Speaker, and decision will be final. His prior recommendation or permission is needed to introduce certain type of bills like bill involving expenditure from Consolidated Fund of India, that is Money Bill and Finance Bill 1. Apart from it, even with respect to union and territory, remember we studied something that if we are trying to create new states, change boundaries of the state, sort of merge states, who exactly do we need to take prior permission from? President of India, right? President of India will then send it to the state assembly and they are supposed to just give their recommendations, right? I mean, it is not at all binding on the parliament to act on it. Again, what we see that there are certain legislative bills, money bill, finance bill 1, or for that matter, this, where you need what? President to first be informed about it and president will do certain important things before it. When a bill is sent to the president after it has been passed by the parliament, he can do what? He can choose to give his assent, withhold his assent, or return the bill. We will discuss about it in veto powers. What exactly are we saying? What we are saying is the fact that a bill becomes an act only when president has signed it. Now, let's say a bill has been passed by Lok Sabha, then by Rajya Sabha, goes to president. What all are the options that he has? Certainly, it is to sign it or not to sign it. So, if he chooses to withhold his assent, that is one thing that he can do. If he chooses to send it back for reconsideration, that is again something that he can do in terms of doing it, right? Then he can also, of course, give his assent. That is another option that president can do. Any confusion? Anyone? Anyone who thinks I'm going too fast? Monica, Atif, fine. Atif, okay. When a bill passed by a state legislature is reserved by governor for consideration of the president can give his assent, withhold his assent, direct the governor to return the bill. Now, if it is not a money bill for reconsideration of the legislature, it should be noted that here he is not obligatory for the president to give assent even if the bill is again passed by the state legislature and send him back for consideration. So let us try to talk about this point in brief. So essentially what we are saying is, what we have state governments, state legislatures. Who exactly is the head of the state? It is governor. Governor is what? Officer who is subordinate to the president. In this regard, what may happen? Let's say state legislative assembly has passed a bill. What exactly governor can do? Governor can give his assent, can also do something, that is he can withhold his assent or he can actually send it to president for reconsideration. Let's say president actually looked into it and president found what? That there are certain things and he wants it to be reconsidered by the state legislative assembly. Then he can send it back and then what can happen? What can happen is the fact that state can reconsider it, if they still decides to send it back to the president, then what president needs to do? He can choose to do anything that he wants. He can choose to give his assent. He can choose not to give his assent. Okay, another point to keep in mind. Let's talk about governor. So let's say a bill has been passed by the legislative assembly. The bill gets sent to governor and he decides, I mean, at his level itself, yeah, this bill seems to be some problems are there. So let me send it back for reconsideration. So it gets sent back to reconsideration to state legislative assembly. Then legislative assembly send it back to the governor. The names are meeting. If they think is fine, then what exactly are the options in the front of governor? Sorry? He has to send to the president. Any other option? Okay, so both are right and both are the options that he has. The idea is he can either choose to give his assent or he can send it for president for reconsideration. What he cannot do, send it back again for reconsideration. He can send it back only once for reconsideration, right? The point we need to keep in mind is that when we talk about President of India and when we talk about president sending back any bill to the Lok Sabha and Rajya Sabha for reconsideration, and if it gets again passed by the parliament and sent it to the president, president has no other choice but to pass it within 15 days. Is it clear? Fine. Anyone getting confused? Fine. He can promulgate ordinances when parliament is not in session. These ordinances must be approved by parliament within 6 weeks from its reassembly. He can also withdraw an ordinance at any time. Ordinance is again a very important power of the president. What is an ordinance? Look, if we want anything to become a law, essentially it needs to be passed by the parliament. But then for parliament to pass a law, the minimum requirement is what? Parliament has to be in session. Lok Sabha should be in session, it passes the bill. Rajya Sabha is in session, pass the bill, then President gives his assent. It might be that we are in a period when Parliament is not in session and there is a very serious or urgent situation which requires a new law to be made by the state in this regard. Now, of course, Parliament cannot be the body that can make it. So essentially, we have something called as ordinance making power of the president. In this regard, what happens? That Union Cabinet Council of Ministers essentially will say, President Sahab, we want this law to be made. This law cannot be made by the House right now because it's not in session. So we require you to please pass it as an ordinance. In this regard, what exactly President is supposed to do? President is supposed to look into the content of it, and if it is not in violation of the Constitution, he can pass it as an ordinance. In other words, ordinance is not a law, but it acts like a law. Its impact, its effect is like a law. And when its impact is like a law, what exactly are we saying? That executive have performed legislative function, something which is not allowed, right? Executive is not there to make laws. It's the job of legislature. In this regard, what exactly is the check that we have kept in place? That it needs to be passed by the legislature. If it fails to get passed by the legislature, it will stop. It cannot be made into an act. It cannot continue. What essentially happens a lot of times, let's say an ordinance has been made. So after 4 months, let's say Parliament gets in session. Before Parliament could actually deliberate on it, the Parliament session got over. So essentially what has happened? Within 6 months, this ordinance will lapse. Modern lapses, what they do? They re-promulgate the same ordinance. They just restart it. Getting a point? So what they are doing essentially is what? What they are doing is they essentially are circumventing legislative authority with respect to lawmaking. In this regard, we have certain Supreme Court judgments that we'll talk about eventually. Fine. This is called as the promulgation of ordinances. Fine. Interesting thing is this ordinance thing was actually kept in the Constitution in a manner in which they had presumed, and they essentially had said in Constituent Assembly also, that it is going to be of extraordinary matters. War ho gaya, we need a new law that to be made, or for that matter, there is a law in place which is acting as an impediment during a time in which there is an emergency situation. We can remove that law by passing an ordinance for such kind of situation. Disaster has happened, something of that sort. But this has now become a way in which your executive is functioning, be it at state level or for that matter at union level. So whenever they essentially want a law to be made, they first pass it as an ordinance, and whenever the Parliament or Legislative Assembly convenes, they essentially pass it as a law also. So तुम्हारे जो farm laws थे वो भी ऐसे होते हैं, अभी कुछ करना पड़ेगा. Am I audible? Dilja. कहाँ थे हम? Fine. So ordinance making power is something which President of India has. What he cannot do, he essentially cannot allow such an ordinance to get passed which is against any of the directions of the Constitution. For example, there is an ordinance that says that Article 19 has been suspended. Otherwise, that's not allowed. So, President, it is the duty of President not to pass such ordinance. Fine. He says that is President lays the report of CAG, Union Public Service Commission, Finance Commission, and others before the Parliament. So essentially all these constitutional bodies, when we study them, we'll see that one of the common features for all these bodies is that annually they are creating a report, and this report gets submitted to the President. What President does with it? He first presents it to the Cabinet. What exactly Cabinet does then? They essentially will give their views with respect to the recommendation. If they agree to it, what exactly will be the action that they'll take? If they disagree to it, what exactly is the reason for disapproval? If they are doing that, then that report along with the report of the constitutional body will be put into Parliament for discussion. Fine. Any confusion? Okay. Acha. He can make regulations for peace, progress and good government of the Andaman and Nicobar Islands, Lakshadweep, Datra, Nagar Haveli, Daman and Diu, Ladakh. In case of Puducherry also, President can legislate by making regulations, but only when assembly is suspended or dissolved. The same goes for Delhi. Fine. Duties may President of India can make those important policies. Now let's talk about financial powers, right? One of the things that you'll see is that many of these powers are going to overlap, but then again, देखो फाइनेंशियल पावर्स मतलब पावर्स विद रिस्पेक्ट टू फाइनेंस, राइट? तो सबसे पहले तो ये है कि मनी बिल्स फॉर इट टू बी इंट्रोड्यूस इन द पार्लियामेंट इट कैन बी डन ओनली आफ्टर अप्रूवल ऑफ द प्रेसिडेंट recommend, then he causes to be laid before the parliament the annual financial statement. What is annual financial statement? Budget को annual financial statement कहते हैं. No demand for grant can be made except for his recommendation. Demand for grant again is what? That more money which is outside the budget, if that money is being requested, that requires approval of the president. Why? But the point is, it is a way in which you are changing the nature of money bill. The money bill which you are taken the permission of the president was the budget. Now you are changing the specifications for it. For any change for you to do, you first would need to again show it to the president and he'll approve it, and then only the matter can go ahead. He can make advances out of contingency fund of India to meet any unforeseen expenditures. So we have something called as contingency fund of India. What exactly is it? There is consolidated fund, contingency fund. Consolidated fund is the Indian treasury. Contingency fund, that if there is any kind of grave emergency that has happened for which money should be taken out, that contingency fund can be used. Who exactly can approve it? President of India can approve it. He constitutes a finance commission every 5 years to recommend distribution of revenues between center and state. He is the person who is constituting the members of finance commission, of course under aid and advice of the union cabinet. Let's say union cabinet hasn't sort of appointed that a union cabinet hasn't constituted new finance commission and 5 years is about to get passed. Then what president can do? You got the question, everyone? The question is very simple. That this is one of the powers that he has, that finance commission ka constitution, that he is the person who will appoint the members of finance commission. Okay? And in this regard, what he says that finance commission tenure is 5 years. Who exactly effectively will be appointing them? It will be council of ministers. Let's say council of ministers have not finished the process of appointing them. Let's say council of ministers might take more than 5 years. Then what exactly president can do? Yes, Dilja. Sorry? He can appoint himself, exactly. He himself can appoint. It is constitutional duty on his part that no more than 5 years should be passed between two finance commission. In this regard, if he is sure of the fact that 5 years will get passed, he himself can constitute it. He himself can appoint them. Getting a point? Is it clear, everyone? Haji.
Like in the point D, the in Kerala fund, like in Kerala there's floods and stuff. So like Prime Minister like didn't award enough relief. So like who is thing was it? Was it the president's assent or like?
Everything with respect to this will be prime minister. That is council of ministers. देखो, there are a number of things. Contingency fund of India has lost its relevance for the reason the money is not that high as compared to the money that essentially requires. So you can essentially fund it. In Kerala, the problem that had happened was that we follow this policy, which essentially says that in matters of national disaster, we do not take aid from foreign countries, right? So there were these countries, UAE, Saudi and all, they essentially wanted to give aids in millions and billions, right? So they decided not to take, Indian government decided that this is a policy we follow, that we do not take foreign aid in terms of such a disaster if it happens, right? So at that time, we were saying that on one hand, you have actually sort of blocked our funds. On the other hand, you're not releasing any funds that is required for us to manage. And when the other countries are providing us aid, you essentially are not helping us out. Now, it was being alleged at that time, the fact that Modi ji was actually doing because the Kerala election was after 1 year or so. So essentially wanted what? That impression to sort of get converted that the state government did nothing for them, right? But then it is not entirely true, to be very honest, for the reason that that has been a policy for very long. But now with respect to COVID, we decided to do away with that policy. Now we are accepting aids from across the world. Fine. See, the reason is that, I mean, with respect to this, I mean, there are both sides to it. My view is the fact that disaster mitigation, humanitarian purpose should not be looked upon from standpoint of sovereignty. It should be looked upon as a global crisis, right? But the idea, the rationale was the fact that if you're taking help from them, That is, with respect to in desperate time, it also makes you obliged. And this obligation on the part of other countries in itself has an implication on sovereignty, that you yourself do not know how to manage affairs of your home, right? तो वो चीज़ हो जाती है, but ठीक है, अभी ले रहे हैं हम लोग. Judicial powers. Let's talk about judicial powers of President of India. He appoints Chief Justice and judges of Supreme Court and High Courts. This again is a very funny business, right? We'll discuss about it, how exactly he appoints it. So what exactly are we saying? So essentially there is, who exactly is going to be a judge? What exactly judge does? Judge essentially deliberates over judicial questions, right? As to what is right, what isn't right, merit of the case and everything. And person who decides who will be the judge is essentially at a broader level is doing this, it kind of, the broader. Are you able to understand my point or not? The point is, नहीं दिल जा तो पूछो ना क्या हो गया. The idea is the fact that judge, in whatever judge says is judicial function, right? With respect to deliberating on who's right, who's not right, what is justice, what is not justice, what is fair, unfair. Who exactly is appointing this judge himself? Getting a point? Because appointing judge becomes a superset of the functioning of the judge. Is it clear or not? Judge जो कर रहा है, it's because president appointed him, right? That means president exercised his wisdom in terms of understanding who can be a judge. And what exactly is he trying to understand in his wisdom? Who has the capacity to perform judicial function. And that is why this provision that president has the power to appoint CJI and of course judges of Supreme Court and High Court is taken as one of the judicial powers of the president. Fine. He can seek advice from Supreme Court on matter of questions of law or fact. However, advice tendered by Supreme Court is not binding on the president. Article कौन सा है? 143. Fine. So what exactly are we saying? If you have the power to direct Supreme Court to do something, that in itself is a judicial power. In this regard, Supreme President can actually ask under Article 143 opinion of Supreme Court on any matter. It could be a matter of constitution. It can also be a matter of law. In this regard, what do we understand? What we understand is the fact that President can actually exercise this power to take consultation from Supreme Court. Now, what exactly do we need to keep in mind? Two things. First, Supreme Court is not bound to tender its advice. अब सुप्रीम कोर्ट को नहीं बताना तो इट्स नॉट लाइक सुप्रीम कोर्ट इट इज बाइंडिंग ऑन सुप्रीम कोर्ट टू गिव इट्स एडवाइस. सेकंड, लेट्स से सुप्रीम कोर्ट gave its advice to the president, it is also again not binding on president to follow that advice. The whole idea is this is just an advice by the Supreme Court of India. Is it clear? Any confusion? He can grant pardon, reprieve, respite and remission of punishment, suspend, remit or commute the sentence of any person convicted of an offence. That is basically pardoning power of the president. We'll understand one by one what exactly do we mean by each of these terms. Again, what we are saying, do you know what is pardoning powers? Pardoning powers essentially means the fact that there is a crime for which court of law has actually held you guilty. And now president is essentially taking away that punishment, putting it very simply, right? In this respect, what exactly are we saying? What we are saying is that president has the power to look into merit of the case, the degree, the quantum of punishment. Is it right? Is it fair? Is it not fair? Again, judicial powers. Are you able to understand? Is it clear? Another point to keep in mind, civil laws, civil crimes are crimes that are made of disputes, civil disputes that happen, right? Divorce, property disputes, so on and so forth. These cases can be taken back by the parties. Okay, we will sort it out outside the court. That is permissible. But when you talk about crime like rape, kidnapping, murder, these are crimes against the state, right? In this regard, can you take it back? No. Who exactly can take it back? President of India. That is what mercy petition means. That when it is when the crime is against society, then it is only the head of the society, and that is President of India who has the power. Yes, Dirja. The president actually, we understand all the powers of president, but president hasn't given absolute pardon. He has made death penalty into life imprisonment and all, right? So we'll understand it here itself. But absolute pardon as to letting you go scot-free, that hasn't happened. In USA, it has happened number of times. Because in USA, the practice that they have is they can essentially use it as a bargaining tool also. Let's say there's a terrorist, for example, right? And the terrorist can actually perform some important functions or some important information. And in return of that information, the terrorist is asking for presidential pardon. So we have those evidence in USA where it has been done. The thing is, in USA, they essentially try to hide these things, and after whatever years, these things actually come out. But in India, we do not follow it, right? So it is only under compassionate grounds, president actually exercises these powers. We'll understand it, right? लेकिन absolute pardon कभी नहीं दिया that you are scot free, right? वो चीज़ नहीं हुआ. अभी देखो अडवाणी जी के साथ शायद दोष है, if he gets guilty. In all cases where the punishment sentence, okay, he can grant pardon, reprieve, respite in all cases where the punishment or sentence is by court martial. So court martial is something that is given by military tribunal, right? With respect to such cases where court martial has been given, it is only the office of president which has the power to reverse this order, right? In all cases where punishment or sentence is by offense against a union law. In all cases where the sentence is sentence of a death. What exactly are we saying? So when we talk about laws, essentially it can be made under union subjects, it can be made under state subjects, right? With respect to laws that are broken, which essentially have been made by the parliament, for these, it is the office of president, which essentially can give you reprieve, pardon, and stuff like that, right? But if it is a law that has been broken of a stateless subject, then who exactly will look into it? Governor of that state. And governor of the state will essentially deliberate on this. What needs to be kept in mind is, if the matter is with respect to death penalty, that is, it can be for the state law also you can be given death penalty, then President of India can actually look into it. Okay? Fine. Of course, you will first go to Supreme Court, and then if Supreme Court also rejects, maintains your death penalty, then President will look into it. Any confusion so far? समझ में आ रहा है ना? Which one? B. See, in all cases, punishment sentence is for an offense against a union law. देखो, law क्या है? Law is on a subject you will make a law. Subjects can be divided into three categories: union law, state law, and concurrent laws. With respect to subjects of union law, subjects on union subject, if there is a law that has been broken by someone and that has given punishment and court has given punishment for it, for all these kind of offenses, the matter will go to president. But let's say it is about a state subject that has been broken, then it will go to the governor. That is what the idea is. Clear? So that is how it. But it can also be on a state subject death penalty has been given. There is a law or with respect to state subject on which death penalty has been given, and let's say High Court gave it, then Supreme Court also gave it, and then it goes to president. President can look into it because it pertains to death penalty. So death penalty can be for union law also, it can be with respect to a state law also.
So, like in cases of like some cases, like the judges might be fake with fake qualifications. They will be appointed with fake qualifications. That is, like,
In High Court. Okay.
So like, can the president interfere because like after he retired, they found out that it's fake. If the judge is fake, like with his qualifications.
Who retires?
The judge, after he retired,
Okay.
they got to know he is a fake judge.
अब रिवर्स कैसे करें? अब तो चला के रिटायर हो गया ना अब तो.
So like, what about the judgments what he passed?
Judgment what is passed, it doesn't get changed. It doesn't get changed. Judgment doesn't get changed. It can be grounds to sort of appeal again. For example, a judgment has been given by Mr. X. He was a judge of High Court. Like in this hypothetical situation, let's say he gave 8 judgments, and then this Mr. X retires, and then afterwards it was found that Mr. X was not qualified for the whatever reason. Now, does the validity of these 8 judgments change? No, it hasn't. But is it grounds for appeal against it? Yes, it is. You can go to High Court or Supreme Court and appeal against these 8 verdicts given by Mr. X on this aspect itself. Okay? Now, diplomatic powers. So when we talk about diplomatic powers, what exactly are we saying? What we are saying is that international treaties, agreements are negotiated and concluded on behalf of President. However, they are subject to approval of the Parliament. He represents India in international forums and affairs and sends, receives diplomats like ambassadors, high commissioners, and so on. So when we talk about union government, they go to like all sorts of international summits. They go participate, they sign treaties and everything. All these things are being done under the name of President of India, right? President himself can also visit and on behalf of the government can actually sign it, of course, on the advice of the Union Cabinet. The idea is with respect to all matters which are executive in nature, which are kind of that will get implemented then and there itself. But if it requires important questions with respect to legislative aspects, it would require legislative approval. Are you able to understand? Acha, there was a case that was deliberated by Supreme Court where Supreme Court said you do not require pre-approval of the legislature to sign treaties. Getting a point? So let's say there is a matter which essentially, just we are here. For example, we are signing this treaty that says we are going to create a law against marital rape, right? The idea is law making will essentially be done by legislature only. It cannot be done by executive. But then this cannot be questioned in the court of law that before signing this treaty, executive never took the permission of the legislature. Supreme Court said that what do you expect? Like they should come back and say, no, wait here, we'll go and we'll take the permission. Treaties are being signed on that pretext, the fact that executive has been given this power, right? And that is also one of the diplomatic power that the president has. Then you have military powers. So you have President of India, who is the Commander-in-Chief of Indian Armed Forces, Supreme Commander of Indian Army, Indian Navy, Indian Air Force. He can declare war or he can conclude peace subject to approval of the Parliament. Fine. अब वो जो था विजय ज्योति, अमर विजय ज्योति for the सैनिक, it should have been, मतलब ideally it should have been President of India must have inaugurated it, not Prime Minister of India. But the reason he is the Commander-in-Chief, it's not the Prime Minister who is the Commander-in-Chief. Why exactly was he not invited? Of course, then President would have to, and then President would have given the speech, something that Modi ji doesn't like. Then emergency powers, in addition to normal powers mentioned above, Constitution confers extraordinary powers to the President to deal with following types of emergencies: national emergency, President's rule, and financial emergency. Again, we will talk about them. What exactly are these powers? So essentially, when we talk about our constitution, it is a federal, quasi-federal, if not completely federal, kind of a constitution. We have state subjects, we have union subjects. But then constitution always thought that it might be that in future a kind of situation might happen where essentially what is required? Speedy decision making. It should not be that we are looking at constitutional procedures in terms of state subject, concurrent subject, union subjects in order to deal with such emergency kind of situations. In this regard, who exactly should be given such powers? Of course, the Parliament. In other words, what we are trying to do when we talk about emergency, we are trying to convert our country into a unitary form of government. It's not a federal form of government. Anyone getting confused? Fine. Take. What's your name?
Girish.
Girish. Fine, Girish. Confused, Girish? Fine, chalo. What I'm saying is, in this respect, what exactly are we saying? What we are saying is that in times of emergency, it might be that we need to change our nature of constitutional functioning, of course, for a temporary period. And in this temporary period, we will impose certain kind of emergencies. Who exactly plays a very important role in this regard? It is the President of India who approves it. Now, again, we will be studying about emergency powers in a separate lecture, but the funny thing is, when the national emergency was essentially with respect to war-like situation where for the whole of country we can declare national emergency. President rule essentially was with respect to state emergency, that is, if a state government or a state legislature is acting in a manner which is not in conformity to the constitution, we essentially can impose emergency. Why? Because we do not want state to have or engage in anything which is unconstitutional, right? In this regard, what will happen is the fact that union will get the power to control all the matters of state. Then you have something called financial emergency, that sovereignty of a country essentially is also dependent on financial stability. At a time when there is financial instability, again, the aspects with respect to what? Center-state financial relationship, what exactly constitutional provision says as to what exactly are the powers of state government, union government, that should not come in way in terms of protecting our financial stability. As such, we decided what? We need to have something called as financial emergency. Now, why I call it very funny? For the reason when Constituent Assembly created this, they believed that this is going to be one form of emergency, which essentially will be exercised for the maximum number of times. And this will be a dead letter, that is President's rule. Dead letter means what? It will never be exercised, right? So what effectively has happened? Do you know how many times we have used President rule? More than 100 times. And how many times we have actually used financial emergency? Zero. We have never used financial emergency. So in effect, we don't really know how what will happen. Like in practice, we know theoretically what can happen, but in practice, what will happen, we don't really know. It's a good thing. But with respect to President's rule, which B.R. Ambedkar thought is never going to get used, so the reason all states are going to act in a proper manner. The idea was Constitution wanted to protect constitutional integrity from any kind of adventurism by the state. But it happened the other way around. It's the union which actually abused the provisions with respect to president's rule in the manner in which they exercise it. Anyways. Ji. No, we'll discuss financial mean in detail, but essentially what it means is this, that it may be that we are undergoing a very big kind of financial stress. And this financial stress, what we see, that constitution actually talks about what? That taxes which center can impose, taxes what state can impose, money that will go in the pocket of center, money that will go in the pocket of state. So essentially there are these rules and procedures which dictates how much union will get, how much state will get. During financial emergency, everything will become union. That is, union can decide on all the funds so that we are able to manage this emergency. Provisions जो है, we will discuss it one by one. Right? अभी तो overview दे देते with respect to president. Fine? Yes, Tirja. See, when because it has never been the idea is if we are undergoing financial stress. So one can imagine 1991 was one situation at the time when LPG had happened, that is liberalization, privatization, globalization. That was one moment where we had witnessed a very high degree of financial stress. But at that time also we didn't impose financial emergency. Conceptually, theoretically, the idea is it is supposed to be exercised when there is a very high degree of financial stress, right? So that's it. Now let's talk about veto powers of the president. ठीक है? Veto powers of the president को हम समझते हैं. The first kind of veto that we need to understand is something that is called as absolute veto. What exactly happens in absolute veto? President can withhold his assent to a bill passed by the parliament. In this regard, what will happen? It will not let it to become an act. What exactly are we saying? What we are saying is the only way in which a bill can become an act is when it is being assented by the president. If president gives an assent, it becomes a law, it becomes an act. What if president does not give his assent? What if president says that I am not giving my assent? He has exercised absolute veto. He has stopped it from getting passed. The question is, what exactly can be the situation where president may exercise it? The first situation is what? The first situation is when the council of ministers essentially are advising him to not sign it. The system that we follow is parliamentary democracy. In this system, essentially what do we believe? That it is going to be a executive driven parliamentary system. That is, executive should be in the same page with the legislature with respect to laws. If executive are giving their sort of apprehension with respect to their capacity to implement the law, then that is a situation, that is a foreseeable or thinkable situation where what can happen? What can happen is president may not actually give the assent. Another such a situation is if a private member bill, if it gets passed, that is, that's a bill that gets introduced by private member. The idea was that there is very less chance for the private member bill to get passed, but then it gets passed by both houses, and now executive, which essentially was not in favor to execute it, has to execute it if it becomes an act. Again, they essentially advise it to the president. The president, sir, please do not exercise this. Now, if you think about it, absolute veto in itself makes very less sense now, because we have what? Anti-defection. Anti-defection means what? Whatever the whip is issued by the individual parties, that needs to be followed by everyone. If the party says vote yes, you will vote yes. If the party says vote no, you will vote no. Effectively, what we are saying is absolute veto, by and large, is almost impossible now to be exercised by Indian president. Are you able to understand? Anyone getting confused in this regard? Fine? Right? It refers to the power of the president to withhold his assent to a bill passed by the parliament. The bill then ends and does not become an act. Usually, this veto is exercised in following two cases. With respect to private member's bill, that is, bill introduced by member of the parliament who is not a minister. Second, with respect to government bill, when the cabinet resigns, this again can be a situation and the new cabinet advises president to not give his assent to such bill. Essentially what we are saying is what? The first one, what we have covered, right? Private member bill, if it gets passed and your cabinet is essentially saying, sir, we do not think we will be able to implement it, we want you to please withhold your assent, then the absolute veto can be exercised by the president. Now, the idea is that giving assent in itself is something that president is actually taking in account what? Advice given by the Council of Ministers. Let's say a bill has been passed by Lok Sabha, Rajya Sabha, and now it is in the table of president. President thought ki yaar, today is Monday, I'll sign it on Thursday. Let's say, right? On Tuesday, your prime minister resigned, all the government got dissolved. Essentially, what has happened? The executive agency which is supposed to implement this law, it is not there. In effect, what he needs to now wait for, whatever the new cabinet that is getting formed, I will just wait for them to get formed. And if they say, President sir, please pass it, I will pass it. If they say, sir, please exercise absolute veto, we essentially will want to reintroduce this bill in a different form. And at that time, we essentially will sort of, that bill is what we would want you to sort of pass. Is it clear what we are saying? Anyone getting confused? Anyone who would want me to explain it again? Nilufar, Monica, Atif, Sia. Fine. Neeraj, Shreyas. Shreyas, is it clear? Yes. Chalo, suspensive veto. Suspensive veto, with it in its name itself, it's clear. It essentially means you're suspending it. So president exercises this veto when he returns the bill for reconsideration to the parliament. However, if the bill is passed again by the parliament with or without amendments and again presented to the president, it is obligatory for the president to give his assent to the bill. This means that presidential veto is overridden by repassage of the bill by the same ordinary majority. As mentioned, president does not possess this veto in case of money bill. President can either give his assent to a money bill or withhold his assent to a money bill, but cannot return it for reconsideration of the parliament. Normally, president gives his assent to the money bill. Chalo, isko hum log samajhte hain suspensive veto. What we are saying is the fact that when, let's say there is a bill that got passed by Lok Sabha, that got passed by Rajya Sabha, then it was sent to the president. President, while reading the bill, essentially felt that this bill requires some sort of amendment, or it could be that this bill would require some sort of reconsideration to be done by the parliament, right? I'll give you another situation. The situation is, let's say, Lok Sabha is about to get dissolved, new election is supposed to happen, and the bill seems to be a bill which essentially is what? Which essentially involves such matters which probably may create more problems for the future government, because you never know which government is going to get formed after Lok Sabha election. So essentially what president can do, president can actually send it back for reconsideration. President can actually send it back for reconsideration that I want you to reconsider this bill. And if this bill again gets sent back to president, what exactly can happen? What can happen is that president then is bound to give his assent to it. So president is supposed to give his assent. He cannot do what? Withhold his assent. Is it clear? Clear or not? Right? Acha. With respect to money bill, can president exercise suspensive veto? He cannot. Why? Sorry? Because it was only when he had considered it is when it became a bill. Now the idea is he cannot. What he can do, he can withhold his assent. How exactly can he do so? We'll understand it in pocket veto, the next one, right? So pocket veto is what? Now this is again very interesting. So what we have is this system where essentially if the bill has been sent by if the bill has been passed by Rajya Sabha, Lok Sabha, and then it gets sent to president, when exactly is supposed to give his assent, in what time frame, that has not been given in the constitution. In other words, president can take his sweet time in terms of deciding that what exactly should he or shouldn't he sign the bill. It's not that he's saying that I'm not going to sign the bill, nor is he saying that today I'm signing the bill. All he's saying, I'm considering the bill. In other words, essentially he has stopped something from becoming an act. In other words, he has stopped that from becoming a law. Are you able to understand? That means it's a kind of a veto. It's a kind of a way in which he has stopped something from happening. It is in this regard, the example which I said actually happened. What had happened was, there was a very controversial bill that was passed by government. President decided to exercise pocket veto. Why? Because he knew new Lok Sabha is supposed to happen. That is, new Lok Sabha election is supposed to get conducted. when this Lok Sabha election will happen, new government will form. At that time, what I'll do, I will exercise suspensive veto. Are you able to understand the logic? The logic is that I want new Lok Sabha to reconsider this bill that has been sent to me by this Lok Sabha, so that this new Lok Sabha also is on the same page. What I do not want is that this Lok Sabha, before it is going to कि हम तो डूबेंगे सनम, right? That is what we do not want. President does not want. Are you able to understand? Is it clear or not? Anyone getting confused? Confused? Russell Peters देखा किसी ने? Russell Peters, huh? Russell Peters, right? So he says that, I mean, very all sorts of racist jokes, but it's entertainable. The point is, he says that in India there's this unique practice. So if they want to say yes, they'll say. If they want to say no, they'll say this. And the best part is, Indians can actually understand. I mean, Indians will be able to understand when they bobble their heads what exactly the other person is trying to say. So that's the thing. Anyways, pocket veto. So about pocket veto, essentially what we are saying is that president neither ratifies nor rejects nor returns the bill, but simply keeps the bill pending for indefinite period. This power of the president not to take any action is known as pocket veto. President can exercise as this power as per constitution does not prescribe any time limit within which he has to take a call on the bill. In USA, on the other hand, the president has to return the bill for consideration within 10 days. Hence, it is remarked that the pocket veto of president, that is Indian president, is bigger than the pocket of American president. Are you able to understand? So American president at best can keep the bill in his pocket for 10 days. Chalo, I'll think about it. But Indian president does not have any time limit in which he can do so. So in 1986, what had happened? What had happened was President Jail Singh exercised pocket veto with respect to Indian Post Office bill. The bill passed by Rajiv Gandhi government imposed restrictions on freedom of press and hence was widely criticized. After 3 years in 1989, the next president, B.R. Venkataraman, sent the bill back to reconsideration, but the new National Front government decided to drop the bill. So let me just briefly explain what exactly had happened here. Pegasus, पता है Pegasus क्या है? Pegasus में the government can actually look into what exactly you are sending as messages. They can read your emails. They can read your WhatsApp. They can read any digital footprint that you may be having, right? ये Pegasus है उस time का 1986 का. So what had happened was Rajiv Gandhi essentially wanted to, on the garb of national security, on the name of national security, essentially wanted to what? He said that, yeah, देखो, national security, it is very necessary that we keep a track of all the messages that are getting sort of sent. So a lot of time these terrorists, what they do, they essentially use Indian Postal Service to send their messages. And for national security, it is necessary that we should have the power to read all the letters. All the tapings and everything can be done by us, right? Pegasus of today's time, right? This is because of national security is why we have Pegasus. In that respect, we perform those activities. He said the same with respect to this bill. So when this bill actually got passed, the President Jail Singh essentially knew the fact that this is done in a kind of haste manner, and possibly they may, that is this guy may actually lose Lok Sabha election. So he exercised pocket veto in this regard. And then he had left the office. New government had actually formed by that time, and the new president, R. Venkataraman, he essentially decided to exercise suspensive veto. That is, sending it back for reconsideration. By this time, you had a new National Front government who decided to drop the bill. Well, they could have decided not to drop the bill, but they did so because that was one of the things that they had promised to the people. It was a widely criticized bill of that time. It should be noted that here President has no veto in respect to Constitutional Amendment Bill. 24th Constitutional Amendment Act of 1975 made it obligatory for the President to give his assent to Constitutional Amendment Bill. Another very important point for your prelims. So when we talk about Constitutional Amendment Bill, that is any bill that has been passed by Lok Sabha, Rajya Sabha and has reached President, then this bill will be taken as something that is will of the people, because it already requires special majority in both houses. As such, what do we say? We say the fact that this is something that needs to be respected by the president, that needs to be done what? That needs to be sent, that is, that needs to be approved. Fine. In this regard, president does not have any kind of veto on constitutional bill. He cannot exercise suspensive veto, he cannot exercise pocket veto, he cannot exercise absolute veto. He will need to give his assent to Constitutional Amendment Bill. This happened after 24th Constitutional Amendment Act of 1977, 1971. Who was in power? Indira Gandhi. Presidential veto over state legislation. What exactly are we talking about? President has the veto power with respect to state legislation. A bill passed by state legislature can become an act only if it receives assent from the governor or the president. In the case a bill is reserved the consideration of the president. What exactly are we saying? Again, the same thing that we had discussed when we talk about bills that are passed by state legislature. Essentially, it goes to the governor. Governor will have the powers, certain veto powers. If governor thinks that needs to be go to the president for reconsideration, for president's consideration, then president can actually exercise again his powers. He may give his assent to the bill. He may withhold his assent to the bill. He may return the bill, if not money bill, for reconsideration of state legislature, or he may reserve the bill for consideration of the president. That is, we are talking about governor. Governor can do all these things. If governor under Article 200, what exactly is the power that he has? Governor may give his assent to the bill of the state legislature. Government may withhold his assent, that is, governor can withhold his assent that I do not want, or he may return the bill if it is not a money bill for reconsideration to the of the state legislature, or he may reserve the bill for consideration of the president. Right? Here, what exactly do we need to keep in mind? उसको समझते हैं. So let's say the governor decides to do any of these two, right? So let's say he decides that I want to exercise option number 3. Governor has decided that I want to exercise, that I want it to be sent to reconsideration, right? The very moment he has sent it to reconsideration for the state legislature and it comes back to the governor, then he cannot exercise his option number 2. What he can do is to give this power to the president. That is, he can send this bill to the president and for president's consideration. Is it clear? Now, president can do what? Can essentially choose to act on it or not act on it. President is not bound to give his assent to a bill reserved by governor for presidential consideration. Is it clear? Even if that bill has been sent back to the governor after reconsideration by the state legislative assembly. This is a very major difference between veto power that president can exercise with respect to suspensive veto in union parliament and with respect to suspensive veto that governor has exercised and then it has reached to the president. Right? Is it clear? Fine. अच्छा, एक और सिनेरियो देखो. Let's say हमारा जो गवर्नर है decides कि I am exercising option number 4. Like a bill, legislature passed it, sent it to governor. Governor decides that I'm not thinking about first 3, I'm exercising directly option number 4. In this regard, what exactly president can do? President can actually ask, apart from other things, he can ask the state legislature, please reconsider this, right? Let's say the state legislature reconsidered and again send the same back. What exactly president can do? Again, he is not bound to act on it. Are you able to understand? Fine. With respect to governor, he is either to give his assent or for that matter send it for president's reconsideration. But for president, he can stop it. He can not let that bill to become an act. Is it clear? When a bill is reserved by the governor for consideration of the president, president can have 3 alternative options. He may give his assent to the bill, he may withhold his assent to the bill, he may direct the governor to return the bill, if not a money bill, for the reconsideration of the state legislature. If the bill is passed again by state legislature with or without amendment, presented to the president for his assent, the president is not bound to give his assent to the bill. This means that state legislature cannot override veto power of President of India. Further, Constitution has not prescribed any time limit with which President has to take decision with regard to a bill reserved by the governor for his consideration. Hence, President can exercise pocket veto also. Any doubt here? Anyone? Fine. Dheeraj, right? Girish, sorry. That is Dheeraj. Sorry, so sorry. Girish. Article 123, ordinance making power of the president. Essentially, what we are talking about, what we had just discussed, that Constitution empowers president to pass ordinances at a time when the parliament is not in session. That is, parliament is under recess. Fine. सेटल हो जाओ सब, पानी वानी पी लो, ठीक है. These ordinances have the same force and effect as an act of parliament, but are temporary laws that are their nature is not that of a permanent laws. They act as law, but then they are still ordinance that needs to be approved by the parliament. The ordinance making power is most important legislative power of the president. It has been vested in him to deal with unforeseen and urgent matters. In this regard, there are certain limitations which President of India is subjected to. What exactly are these limitations? उनको देखते हैं. That he can promulgate ordinance only when both houses of the parliament are not in session. Number one, that is, you need to establish it clearly what? That both houses are not in session. If that is not established, then certainly President does not have the power to pass ordinance. An ordinance can also be issued only when one house is in session, because a law can be passed by both houses and not by one house alone. An ordinance made when both houses are in session is void. What exactly are saying? What we are saying is the fact. How exactly can we make a bill into a law when it gets passed by both houses of the parliament? Let's say both houses of the parliament are in session. Can an ordinance be passed? Why? For the reason, अरे भाई law banana, go to parliament. Let's say one house is in session and one isn't, then can it be passed? It can be passed for the reason that you need second house to essentially pass it. Is it clear? You need both houses to pass it, then only it can become a law, and you believe the fact that it's an unforeseen urgent situation where we require it to be passed. As such, what we see that the power of the president to legislate by ordinance is not a parallel power to legislation. It cannot circumvent legislative mandate. He can make ordinance only when he is satisfied that the circumstances exist where it is necessary for him to take immediate action. So what exactly are we saying? What we are saying is the fact that when we talk about President of India, in his ability to make ordinance, he need to first satisfy himself what? That the matter is of urgent nature. The matter is very important in which he should make this ordinance. And of course, the first condition is what? First condition is the fact that both houses, or at least one house, is not in session. In this regard, what exactly Supreme Court said? Supreme Court said that this power can actually be questioned in a court of law on the ground of mala fide. That is, if we believe the way in which President actually acted is mala fide, we can actually look into what? We can look into whether this ordinance is right or not, and if it is not right, we can strike it down. But then here's the question. The question is, the ordinance power in itself is not stipulating what exactly is urgency. It is not stipulating what exactly is emergency, what exactly is urgent matter. All it is saying is there can be something called as urgent matter, and it is trusting office of president to sort of establish, to be confident and to sort of have this clarity that yes, I believe this order, this situation is urgent. So for the court to look into it, that do we believe it is urgent or not, or do we believe that is court believe is it urgent or not, it will not be right. For the reason constitution is not giving court to determine whether the situation can be called as a matter of urgency or not. Are you able to understand my point? Fine, Girish. Fine. Clear? In this regard, Supreme Court actually exercised a lot of wisdom. It said that we cannot get into what can be called as urgent, what can be called as not urgent. What we can get into is the circumstances in which it was given. If the circumstances are mala fide, then we certainly can sort of strike it down. But then what do we mean by it? Imagine a situation. So what exactly president has power? He has the power to summon and also to prorogue a parliament, right? Let's say on 14th Feb ko, he decides that I want to prorogue the parliament, and on 15th Feb he decides to pass an ordinance. What exactly is he doing? He is using his first power essentially to create a circumstance by which he can exercise his second power. अरे भाई तुम्हें करना ही था, तो अब जो पार्लियामेंट था तो एक दिन और चलाते उसको, you would have passed it, right? The idea is your intent is malified, and that is where we can act. I hope you are able to understand what I mean by it. They are not looking into whether president believed the subject matter to be urgent or not, because it is absolutely clear from the constitution that this wisdom, the responsibility and the trust has been put by constitution in the office of president. But what we can look into in such a malified circumstance in which you are acting, where it is beyond doubt that you could have prevented it. So in Cooper case, Supreme Court held that the president's satisfaction can be questioned in the court on the ground of mala fide. This means the decision of the president to issue an ordinance can be questioned in the court on the ground that president has prorogued the house or both houses of the parliament deliberately with a view to promulgate an ordinance on a controversial subject so as to bypass parliamentary decision, thereby circumventing authority of the parliament. 38th Constitutional Amendment 1975 tried to make president satisfaction final and conclusive and beyond judicial review. So what happened? Government didn't like the fact that why exactly they want to look into how exactly we exercise ordinance power. So they said what we'll do, we will pass a constitutional amendment. In this constitutional amendment, we will say that president satisfaction is final and conclusive. It cannot be questioned in the court of law, even on the grounds of mala fide. Who exactly was in power at that time? Indira Gandhi, right? Then what happened? She lost the power, and then there was something called as 44th Constitutional Amendment that was done in 1978, which was Morarji Desai government. It was a coalition government, right? And they essentially did what? Just a president's satisfaction is justiciable. That is, they reversed the amendment that was done by Indira Gandhi. Is it clear? Right? Indira Maggie, देखिए Maggie. तो Maggie में if you have it without the masala, there is no taste. So Indira Gandhi is that to Indian politics. So it's that masala which makes it very interesting. What happened, how it happened. She passed something, then Supreme Court struck it down. Then his ordinance making power is co-extensive as regards to all matters except duration with the law making power of the parliament. What exactly are we saying? On all the subjects on which parliament can make law, on those subjects, ordinance can be passed by the president. This is what it means, to put it very simply. Parliament can make laws on union subject or concurrent subjects. Parliament cannot make laws on state subjects. Let's say Council of Ministers say that President sir, we want you to make a law with respect to something which is a state subject for Maharashtra. President does not have the power to pass ordinance in that regard. President is bound not to pass that ordinance because it will be unconstitutional. Fine. What exactly are we saying? That ordinance making power of the president is coextensive with the law making power of the parliament. Fine? 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 No. An ordinance can be issued only on those subjects on which parliament has the power to make laws. An ordinance is subject to constitutional limitations as act of parliament. Hence, ordinance cannot abridge or take away someone's fundamental rights. Any confusion here? Fine? Raju? Fine? He's just reading, confirming what I'm teaching is right or not. So, every ordinance issued by the president during the recess of the parliament must be laid before the both houses of the parliament when it reassembles. If the ordinance is approved by both houses, it becomes an act and parliament takes no action at all. The ordinance ceases to operate on the expiry of 6 weeks from the date of reassembly of the parliament. Let's try to understand this. What we are saying is that ordinance was issued, fine, as it as per constitution, yes, but then it is for an urgent matter. It cannot circumvent legislative authority scrutiny. In this respect, what can be done? What can be done is that whenever your parliament reassembles, both houses reassembles, essentially we will give them 6 weeks. Within 6 weeks, they get an opportunity to look into this ordinance. If they believe this ordinance is valid, is something which is required for the country, they can approve it. That will become a proper law. If they decide not to act on it, it will become what? They are not bound to sort of approve it. That means it will stop. Its effect will stop. Is it clear? Clear or not? What exactly are we saying? From the date on which your parliament is convened, 6 weeks will be counted. What we are not saying is from the date on which ordinance is passed, 6 weeks is getting counted. Are you able to understand the difference? Let's say today we passed an ordinance, right? And on 1st March, Parliament is getting convened. 6 weeks will be counted from 1st March, not from today. Clear? What can be the maximum period between two sessions? Not more than 6 months, right? That means, let's presume that yesterday Parliament was prorogued and today an ordinance was passed and we stretched our 6 month period. So effectively, what will be the maximum, what can be the maximum life of an ordinance? 6 months plus 6 weeks. Is it clear? Anyone getting confused here? The ordinance may also cease to operate even earlier than the prescribed 6 weeks if both houses of the parliament passes a resolution disapproving it. If the house of the parliament are summoned to reassemble on different dates, the period of 6 weeks will be calculated from the later of those dates. Fine. अगर मान लो राज्यसभा आज हुई and Lok Sabha got convened after 4 days, so it will be on the second house, that is Lok Sabha in this example, from where we will calculate as 6 weeks. Fine. This means that the maximum life of an ordinance can be 6 months and 6 weeks in case of non-approval by the parliament, 6 months being the maximum gap between the two sessions of the parliament. Is it clear? The point which I explained, that maximum can be 6 months plus 6 weeks. If an ordinance is allowed to lapse without being placed before the parliament, then the act done, completed under it before it ceases to operate, remain fully valid and effective. What exactly are we saying? देखो, ordinance banana is a power that president has, of course, under the immediate advice of union ministers, right? In this regard, ordinance is acting like a law at least till the time in which it has been approved or disapproved. Let's say in this example we say that it is going to get disapproved, right? Let's say today, or let's say on 1st of Feb, we decided to pass an ordinance, and on 15th of Feb, Parliament decides to disapprove it, right? Now the question is, from 1st of Feb to 15th of Feb, this was acting like a law. Of course, from 15th of Feb onwards, this is not going to be a law anymore. But till this period, it was acting like a law. In this period, when it was acting like a law, what exactly could have happened? There are people who would have been sort of had to sort of pay, say, a penalty on it, or essentially got affected by it. Now, the fact that it has been cancelled by the parliament, does it mean all those actions that has been done, all those ways in which people got affected by that ordinance, that also must be reversed? No. Are you able to understand? Is it clear or not? Let's say by an ordinance it is passed that we are changing the Motor Act law, and now for any person not wearing a helmet, we essentially will impose 1.5 lakh rupees as well. वो तो स्कूटर ही दे देगा अपना, भाई यही ले जाइए. Yes. Anyways, now after 15 days, if it gets sort of cancelled, then what exactly all the people who essentially were made to pay those 1.5 lakh, they essentially can do what? They cannot ask that this should be refunded because it has been cancelled. Of course, they can always go to judiciary, right? That they believe injustice has happened, it was frivolous and everything. But then the fact that it got cancelled after 15 days does not mean all those people who were charged 1.5 will have to be. The president can also withdraw an ordinance at any time. Now, the thing is, of course, let's say on 1st of Feb, the ordinance got passed. Now we are waiting for Parliament to approve it. Now that we are waiting for Parliament to approve it, till that period it is acting like law. Let's say within 4 days, or let's say by 7th of Feb, President or the government feels that it does not require us to have this law anymore. Are you able to understand? Let's say we have enough evidence to say that China is going to attack us. In that respect, we created a law, a kind of ordinance that got passed. Now, of course, after 15, 20, whatever days, when Parliament got reconvened, it has to be put in test. But within 7 days, we actually found that the situation for which we needed this law, it seems very unlikely it is going to happen. So what exactly can we do? The president can unilaterally take back this ordinance. That is, it does not have to go to the scrutiny of the parliament, because now the question for that reason for which you wanted this ordinance has ended. Is it clear? Fine. So taking it back is very easy. It's not a problem. At any point of time, president can take it back. President can also withdraw, right? However, his power of ordinance making is not discretionary power. He can promulgate or withdraw an ordinance only on the advice of Council of Ministers headed by Prime Minister of India. Fine. Now let's talk about pardoning power of President under Article 72. Fine. So pardoning power of the President, what do we see? The president has the power to grant pardon to persons who have been tried and convicted of any offense in cases where A. Punishment or sentence is by an offense against a union law. B. Punishment or sentence is by court martial, military court. Or C. Sentence is a sentence of death. What exactly are we saying? These are the three cases where president will have the power to, what we say, power to pardon. Fine. In this regard, if a law that has been broken for which punishment has been given and this law is a union law, president will look into it. Then if it has to do with court martial, again president can look into it. Why? Commander-in-chief is President of India. Since a sentence is a sentence of death, death penalty, again president can look into it. The pardoning power of the president is independent of judiciary. It is an executive power, but president, while exercising this power, does not sit as a court of appeal. Fine. The object of conferring this power on the president is twofold: to keep the door open for correcting any judicial error, and to afford relief from a sentence which president regards as unduly harsh. So what exactly are we saying? What we are saying is that we essentially had modeled our office of president around the crown of the British. So there's nothing above crown, right? So essentially what we said was the fact that president essentially should be that head of the society who must have the power to pardon. In this regard, what they said that when president is exercising it, it is kind of like quasi judicial powers. But then it needs to be looked upon as a separate power from the way in which judicial proceeds. Why? Because judiciary is bound by judicial procedures, by all sorts of protocols, by performing what is called as natural justice. What is natural justice? Both parties will be called upon, the parties will be asked for their defense and everything. While president is exercising his powers in that manner, president is not bound to practice any of these. Are you able to understand? President essentially is trying to do what? If it becomes absolutely clear that there is some sort of error that has happened, president is at least that level where you can actually go and get the mercy. The second thing is that if president actually thinks the fact that the punishment that has been given is unduly harsh, then again president can act in a manner in which the president is able to bring some relief. What exactly can be that circumstance? We'll talk about it, but I hope you're able to understand the logic. The logic is just the fact that there's another point to keep in mind. Let's say a decision has been given by a Supreme Court, right? The decision is, let's say, death penalty to Mr. X. The person can always go for presidency. But can the person, Mr. X, again go to Supreme Court for relief? He can. There's something called as review petition. They can actually review their old decisions. Review petition is an option that people have. Although it's more of a lawyer's thing, but now last time they had asked a question with respect to review petition in High Court. Can you file review petition in High Court with respect to High Court order? Yes, you can. Right? The same manner with respect to this. Just the fact that there's a order that has been given by Supreme Court. Yes, you have the option of going to President, but then you can again file for review petition in Supreme Court. Are you able to understand? Is it clear? Anyone getting confused here? Dirja, right? Siddharth, Girish. Now let's talk about the meaning of what exactly do we mean by pardon? What exactly do we mean by presidential powers of giving mercy, and what exactly are the terms that we need to keep in mind? First is pardon. Pardon means it removes both sentence and conviction and completely absolves the convict from all sentences, punishments, and disqualifications. So what exactly are we saying? What we are saying is the fact that with respect to conviction, sentences, and all sorts of punishments and this that has been given, president can actually take it completely back. In Constituent Assembly debate, they essentially said the reason why we may require this has more to do with the fact that there could be a case where a freedom fighter essentially is alleged with something, and now that we are independent, but the laws will still be, some of the laws that are there by the British creations might still be active. We essentially would want to absolve that person of all the things because we believe that person to be a freedom fighter, someone like Bhagat Singh, for example. So if that category of case is coming, so at least with this exercise, we essentially have a way out in order to absolve this person. Fine. Any confusion here? It simply means वो देखे 24 जो जैक बार नहीं commutation. So let's talk about commutation. It denotes substitution of one form of punishment to a lighter form. What exactly are we saying? That what we are saying is the fact that a person who has been given one form of punishment, president believes it is unduly harsh. It is, we can actually decrease the incidence of the punishment. So for example, someone has been given death punishment. Now that can be commuted to rigorous imprisonment, which in turn be commuted to simple imprisonment. What exactly are we saying? So let's say someone has been given 15 years with rigorous imprisonment. Commutation for him will be 15 years with simple imprisonment. Someone has been given what? The death penalty. Commutation would be that I'm bringing it down to life imprisonment. For life imprisonment with rigorous imprisonment, right? The idea is that I am just substituting the form of punishment that you have to a lighter form. Is it clear? Anyone getting confused? Then remission, it applies reducing the period of sentence without changing its character. For example, someone has been given 10 years of rigorous imprisonment. Character is rigorous imprisonment. Duration is 10 years. What you are doing? You are reducing the duration without the character. Reducing it from 10 years to 5 years. Rigorous imprisonment. Remission. Right? Cancer is in remission. Right? Character is still the same. You suna na cancer is in remission term that is used. Nahi suna. So someone has a cancer, so essentially they go for chemotherapy, all sorts of radiation therapy. Then there is this whatever the tumor or whatever that is formed that gets getting shrinked. So when it is shrinking, its character hasn't changed. It is still cancerous, but then its size is getting smaller. So what we say, it is in remission. Is it clear? Then respite, it denotes awarding lesser sentence in place of one originally awarded due to some special reason. Let's say there's a woman who essentially got alleged, who got convicted, and the nature of punishment is 7 years, right? But then it was found, let's say for whatever reason, in her third year, she gets pregnant. In this regard, what exactly is happening? The nature of the punishment that she is getting is going to affect a newborn. In this regard, what exactly is happening? The someone who's actually getting punished is someone who never committed that crime. So what we want to kind of balance it out. So this becomes grounds for something called as respite. That ठीक है, but the point is now it's a very extraordinary kind of a situation where essentially we want what? We want the child to be protected. Fine. Another interesting thing, although I need to recheck it once. So there's something called as fetus and there's something called as baby. You know what's the difference between the two? From standpoint of law.
Fetus is in the womb, no?
It is baby is also in the womb. Baby has human rights, has fundamental rights. That is the difference from the law. And that is the threshold to decide should abortion be given or not. Are you able to understand or not? In developed countries, that after a point, generally it's 3 months, after a point, that baby has fundamental rights. You cannot abort that child because now baby has fundamental rights. That fetus is no longer a fetus, it's a baby, it's a human, right? In India, abortion is allowed only for medical reasons. So abortion essentially, and for if a baby is outcome of rape. So if it's an outcome of rape, then again, abortion is something that is legally permissible. But then if the abortion is outcome of unplanned pregnancy or marriage or sort of a pregnancy outside the union of marriage, for this it is actually illegal. But then what happens is that wo jo doctors hote hain, they have been given this kind of flexibility to essentially put it into medical grounds for which they can terminate pregnancies. Are you able to understand? But then in India, you're essentially not supposed to terminate pregnancy on the grounds that someone has undergone pregnancy which was either unplanned or it is outside the union of marriage. It is only from standpoint of medical grounds on which it can be done, right? But this is deep if you think about it, no? It's when do you decide that the fetus starts having fundamental rights is when you cannot kill that baby. Deprive, it implies a stay on the execution of a sentence, especially that of death, for a temporary period. Its purpose is to enable the convict to have time to seek pardon and commutation from the president. What exactly are we saying? What we're saying is, let's say, Supreme Court of India says that this Mr. X has been given death penalty and this has to be executed on 20th of Feb. Mr. X would say, sir, Judge Sahab, I would need time in order to make a case that I can send to the president. For the reason, if I'm asking for pardon or commutation or remission, or for that matter, remission or respite, essentially I would need to build a case that president can consider. If you're not giving me 6 days, you're giving me only 6 days, how exactly will I do it? So my petition will be with respect to deprive that President Sahab, please delay my date for the reason I require what? More time to present my case to you. Because it seems that Judge Sahab, or that a Supreme Court judge, has actually given me punishment which does not allow me to make a case for presidential pardon. Is it clear? Are you able to understand the circumstance? Another point to keep in mind is that when you talk about, so when someone has actually applied for presidential pardon, there is no limit as to what time that president can take on deliberating on this issue, right? So let's say there's a situation where Mr. X has been given a death penalty and it matter went to president and president decides to sit on it. Then the president changes, new president comes, then he decides to sit on it. Then the third president comes. By this time, around let's say 8 or 9 years has been passed. This third president says death penalty to this guy. Now what has happened? It is a kind of double jeopardy for the reason this person actually was in 8 years of jail while waiting for his verdict from the president, and it is resulting into what? A kind of agony in which he has lived. In this respect, what Supreme Court has said, that if there is unreasonable delay on the matter of on the part of a president to decide on matter of that is pardon or respite or whatever, and the punishment is that of death penalty, it can be grounds for what? Appeal. You can again ask for review petition if the president took more than sufficient time in order to discuss on your matter. For the reason, if we are not providing you, we are subjecting you to double jeopardy. What is double jeopardy?
No person can be punished for the same offense.
So much twice. So there are two types of punishment that person is actually undergoing. One is imprisonment, and second, subsequently death penalty. Acha, मान लो if the president after 11 years decides not to give death penalty, then it's fine. Then there is no case for review. Getting a point? But the order of the Supreme Court is upheld after 10 or 9 years, 11 years, whatever. Then it's a case where you can file for review petition. Is it clear? Okay. Under Article 161 of the Constitution, the governor of a state also possesses pardoning power. Hence, the governor can also grant pardon, deprive, respite, remission of punishment, or suspend, remit, commute the sentence of any person convicted for an offence under state law. Fine. But the pardoning power of governor will be different from president in what respect? Number one, with respect to court-martial, military courts, only president has the power to give pardon. And president can pardon death sentences while governor cannot. Even if the state law prescribes death sentence, the power to grant pardon lies with president and not the governor. However, governor can suspend, remit, or commute a death sentence. In other words, both governor and president have concurrent power in respect to suspension, remission, and commutation of death sentence. Let's try to understand this point. What we are saying is that we were absolutely clear with respect to the fact that if there is a law that has been broken and that law belongs to a law made by union, it is going to go to president with respect to any kind of presidential pardon, right? The second thing we said is if it is with respect to any kind of punishment inflicted as a product of you breaking a state law, it will be the governor of that state which will look into it. But then what we said with respect to matters of court martial, it will go only to the president irrespective of where exactly that crime was committed. Second, what we said that with respect to death penalty also, it is only the office of president which has the power to grant pardon, that is absolving someone from death penalty. But with respect to respite, reply, all those things, even governor can do so. Commutation and all. Are you able to understand what I'm saying? So death penalty is the punishment, and what we are trying to do, absolve him. That is totally make him go scot-free. That is a power which only president has. Again, a point where your UPSC might try to trap you. Fine? Is it clear? Acha, tell me this. Does governor have the power with respect to hearing mercy petition for death penalty? Yes or no? Yes. But they don't, the governor does not have the power to give pardon. That is the only point that we need to keep in mind here. Fine? ठीक है? Supreme Court examined the pardoning power of the president under different cases and laid down following principles. Number one, now this is what Supreme Court has sort of clarified with respect to presidential powers of pardon. Petitioner for mercy has no right to oral hearing by the president. What exactly are we saying? Let's say Mr. X has been given some punishment by Supreme Court. Now the matter is being heard by president. Mr. X cannot say, I want to meet president and want to explain it to him what exactly is my situation. That is a power that you do not have. Are you able to understand? Oral hearing. Whatever you want to communicate, write in a piece of paper, whatever the way in which president suits will. If the president wants to meet you, that's a different case. President can always call you. But you do not have the right for oral hearing. Is it clear? Second, president can examine the evidence afresh and take a view different from view of taken by court. So one of the questions that was raised was the judicial power with respect to this would require what? Judicial independence, would require judicial merit and everything and all. Are we trusting the office of president with too much when we are giving them power to examine the evidence, power to sort of take a position which is different from that of the learned judges? उनको my lord कहते हैं ना, they are lords, judges of Supreme Court. The idea is that are we giving president too much power with respect to it? Supreme Court said no, nothing like that. President has the power to look into evidence, has the power to look into it with new eyes, and of course can take a position different that of Supreme Court. So like I said, a citizen can also do the same. They can also take a position except different from that of Supreme Court. So there's nothing which stops even president to do so. The power is to be exercised by the president on the advice of Union Cabinet. This again is something that we need to keep in mind. It is not president essentially who's taking this call. It is the Union Cabinet which essentially is taking this call. President is not bound to give reasons for his order. Let's say president decides to pardon Mr. X, and then media is asking, sir, what is the reason? I'm not bound to give that. If he decides not to pardon Mr. X, then again president is not bound to give his reasons. President can afford to relieve not only from a sentence that he regards as unduly harsh, but also from evidence mistake. What exactly are we saying? One question that was put was the fact that does president in his exercise of power, does his power means only when he's actually looking at the nature of punishment and thinking this punishment in his understanding is too harsh, or is it the fact they can actually look into the evidence? क्यों हुआ रेड्डी? कुछ तो हुआ है, बताओ स्माइल अभी भी बंद नहीं हो रही, तो बता दो क्या हुआ? हाँ Madhu, what happened? Okay, tell me afterwards. So what I'm saying is that the idea is that president's power also extends to looking into merit of the evidence, looking into Evidence Act, looking into can this be taken as a permissible evidence or not. Hang on. Then there is no need for Supreme Court to lay down specific guidelines for the exercise of power by the president. So the request was, sir, आप बताओ what should be the way in which president should be looking into it, what are the procedures and protocols they should follow. बोलते कि that is not our job to do so with respect to this. President is Mahamahim. Mahamahim समझते हो? That the greatest of all, Mahamahim. That's what it. The exercise, but I'm not kidding. This is how he is addressed, Mahamahim. That is greatest of all. The exercise of the power by the president is not subject to judicial review except where presidential decision is arbitrary, irrational, malified, or discriminatory. So what they are saying is, with respect to this, it is not subject to judicial review except when it is clear that the president's decision is arbitrary, it is irrational, malified, or discriminatory. It is in this regard, Supreme Court has clarified that example that I gave you, that if it is taking too long for president to, this is arbitrary, it is irrational. And that is what we can actually review, right? Then where the earlier petition for mercy has been rejected by the president, stay cannot be obtained by filing another petition. But exactly as we're saying, what we're saying is that let's say this Mr. X, he essentially has been given death penalty. Then what happened? He filed for mercy petition for the president. President took, let's say, 6 months to decide on it. The president says that I do not want to stop his death penalty. Mr. X should be given death penalty. Mr. X decides, okay, I'm again filing for a new mercy petition to the president. And that is why I need, more time in which I can file a fresh case. They said, no, it can be exercised once. Once you have exercised this cannot be the grounds for you to ask for more time. Can you file it again? There's no one who's stopping you from filing it. But this cannot be grounds for you to extend your date of execution. Fine? Any doubt here? अब चलते हैं वाइस प्रेसिडेंट ऑफ इंडिया पे. What happened, Joshua? कल लेक्चर भी मिल गया ना, बोलोगे भी नहीं. हाँ जी, नहीं हुआ अभी. भाई अभी, अरे yesterday also explained this. I think I'll just make a video and put it on Rao's YouTube channel to explain you the process. देखो मैं बता रहा हूँ ना कि it's not now you'll realize the fact that time is less. It's towards the end of those lectures you'll actually realize कि सर ये नहीं हुआ वो नहीं हुआ. तो अभी whatever we can push for, let's try to get it done. Is it visible? Online students, Nilufar, Monica, Atif. It's visible, right? But it's visible in a very weird sense, no? Fine. Who's he? Okay, Naidu, Vice President of India. Fine. Article 63 of Indian. Many of these things we have studied. Fine. So let's go through them. बात सॉरी इट्स अ टॉफी चॉकलेट देख के परेशान हो रहा है वो. Article 63 of Indian Constitution talks about what? Of the Constitution provides that there shall be Vice President of India. So article, there is no escaping it now. You have filed for your petition that has been rejected. Chalo. Article 63 of Constitution says what? There shall be Vice President of India, right? The office is modeled around the lines of Vice President of USA. How exactly? Because whenever the President is not active, your Vice President will step in and he will act as President. The office is needed for dealing with any contingency that arises due to temporary inability of the President to discharge his duties, or when there occurs a vacancy in the office of the President. So what exactly are we saying? That the way in which we design the office of Vice President, it is more to do with contingency. Only thing to keep in mind is it is kind of an inverter backup. That is something that should never make you to get confused. Indian Vice President is only there to act as a backup to our President if the President in any way is inactive. If the President steps down, Vice President will be in the office till the time new President is elected. Vice President will not continue for the remaining tenure, unlike the system in USA. In USA, if Joe Biden, for whatever reason, if he steps down, Kamala Harris will complete the term. Kamala Harris is the Vice President of US. At least by that, that way they'll actually be able to get a woman president. According to Article 65, in the event of the occurrence of any vacancy in the office of the President by the reason of his death, resignation, removal, or otherwise, Vice President shall act as President until the date on which the new President of India is elected. क्यों कर रहे हो? Right? Then, when the president is unable to discharge his functions owing to absence, illness, or any other cause, vice president for that period will essentially be doing what? Will be discharging the functions of the president. Another point to keep in mind: every time he fills in up, he again takes oath. Right? That is again something that we need to keep in mind. When the president is so acting or discharging the function of the president, he shall have all the powers and immunities of the president. He will be entitled to such emoluments, allowances, and privileges as may be determined by the parliament by law. That is applicable on president. The same will be applicable on vice president. Not perform the duties of office of chairman of council of states. What exactly are we saying? That your vice president is also what? Ex officio, what? Chairman of council of states. That is Rajya Sabha. Now, if he is acting as president, certainly he cannot go and sit in Rajya Sabha. Idea is when he is acting president, he will not be performing the duties of chairman of Rajya Sabha. He shall not be entitled to any salary or allowances payable to the chairman of Council of States under Article 97. Another point to keep in mind is when your president, that is vice president, is acting as chairman of Rajya Sabha, he gets the salary of chairman of Rajya Sabha, not the salary of vice president. Clear? When he is acting president, he gets the salary of president, not acting president. Fine? He gets the salary of president of India. Right? Why not vice president? Because as such there is nothing for vice president to do. It is for chairman of Rajya Sabha to do. So if you do something, then only you get paid, right? So that is the idea. During the normal times, when such a contingency had not arisen, the vice president is the ex officio chairman of Rajya Sabha. As the chairman of Rajya Sabha, the vice president is entitled to such salaries and allowances fixed by the law. Now, what exactly do we mean by ex officio? Ex officio, I think we have covered this point also once. Ex officio means by virtue of holding one position, you will automatically be holding the other position. Are you able to understand? By virtue of being leader of opposition, you are ex officio member of selection panel of CBI director. By virtue of being chairman of, by virtue of being vice president, you are ex officio chairman of Rajya Sabha. Is it clear? Ex officio means by virtue of holding one position, you will be holding other position as well. Now let's talk about qualification for someone to become vice president of India. Article 66 lays down qualification for the office of vice president. Accordingly, the vice president must be a person, first of course, citizen of India, must have completed the age of 35 years, be qualified for election as member of Council of State. Why Council of States? Because he will be the presiding officer, right? He will be the person who will preside over Council of States. What is Council of State? Rajya Sabha, right? Not be holding any office of profit under Government of India or any government of state under any local or authorities. To put it simply, the person should not be holding office of profit while being in the office of vice president. The following are exempted from being office of president for the purpose of being elected as VP. First is president, VP of the union, that is a VP essentially is trying again for this. Governor of any state, there is governor of state who essentially wants to apply for vice president of India, and minister of union or of any state, that will not be taken as office of profit. We will have a lecture. I'm thinking of creating a video for office of profit explaining everything, so that will be there because उसमें confusions बार-बार भी आते रहेंगे. Fine. Election of vice president. How exactly vice president is elected? You want to understand today? It's actually simple, don't worry. Right? That's the confidence. The vice president is elected by electoral college, who will be consisting of what? Who will be consisting of the both houses of the parliament with a system of proportional representation by means of single transferable vote, and the voting at such election shall be a secret ballot. In the original constitution, it was provided that the election will take place in a joint sitting of both houses. However, by 11th Amendment 1961, the provision for joint sitting was removed. The vice president shall not be the member of either Lok Sabha, Rajya Sabha or any state legislature. In case of member of parliament or state legislature is elected as vice president, his seat in the house will fall vacant, right? This implies that Constitution does not bar member of Parliament or state legislature from contesting election of office of Vice President. Let's try to understand it one by one. So essentially, in the election of Vice President, who exactly forms the Electoral College? Lok Sabha and Rajya Sabha. What exactly is the process that is followed? Proportional representation by single transferable vote. What exactly is the good thing? That states are not getting involved. So the calculation will not be very tough. Now, in this regard, what exactly do we need to understand? That a whip can actually apply for it again, and even members of state legislature assembly or member of parliament can also apply for the election of. So हमारे जो वेंकैया नायडू थे, he was member of parliament, right? And then he became vice president. Another point to keep in mind, and this is a kind of, you say, criticism or doubt. Point is, what we are talking about is a very important position of vice president. Why? Because in the event president is not active, he will be delivering functions of president. On one hand, when we talk about president, we said that essentially we want a person who enjoys the confidence not only of your parliament but also of state legislative assemblies of all of India. In this regard, what we are doing is we are creating an office of vice president where we are not taking their assent, but we are also stipulating that in the event president is not there, he will automatically will be delivering the duties. In this regard, one can call it to be a provision that is anti-federal, because the vice president, whenever जैसे वेंकैया नायडू, let's say he goes on छुट्टी हमारे कोविंद साहब, so a vice president Venkaiah Naidu will be acting as president. Let's say he acts as acting president for 14 days. In this regard, he will be president for also state. He essentially will have the power to reserve their bill. He essentially will have the power to sort of impose president's rule. In this respect, the question is, isn't it unfair on the part of constitution against the states in this regard? To an extent, yes, but then there were reasons for it. The first and foremost reason was the fact that vice president, when you look at what exactly he is supposed to do, it is so passive that it makes less sense that we have such an extensive system, जो हमने देखा था वो पूरा, right, for vice president. The second thing was that he's always going to act like a inverter backup. That is, it's not the fact that vice president will be in office continuously and he'll deliver on the duties as what happens in US. In India, what exactly will happen? What will happen is the fact that vice president essentially will be there till you are able to get the new president installed. In that respect, again, it made more sense essentially to limit it only to your Lok Sabha as well as Rajya Sabha as far as election of vice president is concerned. Is it clear? Anyone getting confused here? Right? Term of office. Vice president will hold the office for the year term of 5 years from the date on which he enters upon the office. Article 67. This is slightly interesting. Why? The reason, what exactly we're saying, term of office of vice president is 5 years. Which house is he presiding? Rajya Sabha. What is the term for a Rajya Sabha member? 6 years. This is where it becomes interesting. Never let it confuse you. So they can give you a statement and say the fact that term of members of Rajya Sabha and chairman is 6 years. So essentially you think yes, it must be, the flow of it. For vice president, the term is 5 years, but for members of Rajya Sabha, it is 6 years. Fine. This means that with respect to Rajya Sabha, the chairman will have a term of 5 years, whereas the members are going to have a term of 6 years. However, VP will continue to hold the office even after his term expires till the next VP is entering the office. Again, the same logic. The idea is that, well, as far as possible, we would want that by the end of 5th year, essentially before the end of 5th year, we have a new VP ready who's going to take over the office. But let's say that hasn't happened. On 1st of January, we were supposed to have a new VP and we weren't able to find one. So let's say by 15th of January, we can have a new VP. Then till 15th of Jan, the incumbent can actually continue. Important question. On 15th of January, essentially what has happened? The previous VP has spent 5 years, 15 days more, right? Then when the next VP enters the office, what exactly will be the term that he will be serving? 5 years, right? So it's not uske 5 years se ab minus kiye jayenge, right? He will be getting a full term of 5 years. Now it will be calculated from the date on which he enters the office, that is 15 Jan, right? Clear? The office of vice president may fall vacant before the expiry of the term by reason of his death, resignation or removal. VP can resign from the office, writing his resignation to whom? To President of India. He can be removed from the office by a resolution by Rajya Sabha supported by majority of then members and agreed to by Lok Sabha. Again, what we are saying is the fact that essentially what is required for removal of VP is that you need to be able to pass the resolution in Rajya Sabha, where essentially who exactly should be able to pass it? The then members of Rajya Sabha, that is majority of then members of Rajya Sabha. What do we mean by then members? So the strength of the House of Rajya Sabha is what? 245, right? Let's say for some reason 15 members, that office is vacant, that is the seat is vacant of 15. So then members are 230, right? Are you able to understand? So what will be majority of 230? 136. CSAT kar lo yaar. Right, 136, right? So all that we require is 136. Why? Because that is majority of then members of Rajya Sabha, right? Let's say it gets done in Rajya Sabha, then what exactly do we need to? We will be sending it to Lok Sabha, where what is required is only simple majority. What exactly are we saying? It is very easy, or rather comparatively very easy to remove your vice president as compared to the president. Since the electoral college electing the vice president includes members of Lok Sabha, it is essential that the resolution to remove him needs to be agreed by the House. That is, what we are saying is, for Lok Sabha, it is necessary that they just agree to it. But for Rajya Sabha, what is required? Effective majority, that is, then membership की more than 50%. Fine? Any confusion है? हाँ जी.
The election process of president and vice president are both same.
हाँ, but in president you're
differentiated, like
हाँ,
they elect president and vice president.
the system is the same, but then वहाँ पे you need to do what in vice president? You first will need to conduct this election in all the states, and then you will be assigning value to it. Then you will be essentially doing the same. Are you able to understand? But here the valuation वाला चक्कर नहीं है. The valuation is all members are at par. That is the difference. Are you able to understand the point or not? अभी उसमें हमने देखा था ना कि essentially what we are doing is that for election of the president, the election will be conducted for every state. Then for every state, we will be calculating vote, total value of the vote of that state. Then we'll add it for all the states. Then we'll get to that figure, which essentially needs to be equated with the value of votes of MPs. And then we will get to the individual value of every vote of an MP. And from there, we will actually look into what? We will look into who exactly is voting for whom and what exactly is the value that he is bringing to that candidate. And that value का 50% is what we are trying to find. यहाँ पे चक्कर नहीं है. यहाँ पे it's just that we will do it by a single, that is proportional presentation by single member transferable vote. There is nothing called value वगैरह. सब is everyone is equal. Fine. चलो, we'll do it tomorrow. Fine. I was hoping to cover the whole of president, vice president by today, but chalo. Okay, Atif, Nilufar, Monica, Neeraj, Shreyas.
Vice president can declare emergency.
No. No, I mean, when he's acting president, when he's acting, he's full president. Vice president, there is no limitation on acting president with respect to what he cannot do. Vice president do everything a president can do.